Court is now calling City of Pontiac versus Philip Colton, case number 23 TRD 802. Good morning. Mr. Colton, did you understand all of the rights and plea options I explained to everyone?
For the most part, if I'm not wrong, I am entitled to a crash report or an accident report, I should say.
Well, if you're not wrong, then you want to plead not guilty today, right?
Yes, sir.
Okay, so, and that can be obtained by you and or your attorney from the law director or the prosecutor's office.
I have asked, I've went to records and it is not available.
Okay, well, we can deal with that later.
Okay.
This is your initial appearance hearing. Did you have any questions about the rights and plea options I explained to you earlier?
No, sir.
Did you receive a copy of this traffic citation that was issued on November 4th, 2020?
Yes, yes, sir.
Okay, you are charged with one count of stopping after or failing to stop after an accident or leaving the scene of a crash or accident. A violation of section 335.12A1 of the Pontiac City Ordinances. If you're convicted of this offense, it's first degree misdemeanor. If you're convicted of this offense, you face a maximum 6 months in jail and a maximum fine of $1,000. Do you understand that?
Yes, sir.
Also, if there is anyone who is damaged as a result of your actions and you're convicted of this offense, the court could order restitution, order you to pay restitution to that victim of up to $5,000. Do you understand that as a possible consequence? Finally, if you're convicted of this offense, you face a minimum license suspension of 6 months up to a maximum 3 years. So do you understand that as a possible consequence? And how do you wish to plead to this charge? The court will accept your not guilty plea. Are you asking the court to consider appointing an attorney to represent you?
No, sir.
Okay, will you be retaining an attorney?
No, sir. I'll be representing myself.
That's not a wise thing, Mr. Colton, to represent yourself. You're not an attorney. You don't know the legal processes. So I
do have that right, though, right?
You sure do, sir.
Okay.
Just because you have the right to do something does not always mean it is the wise thing to do. You may have the right to represent yourself in court, just like someone technically has the freedom to make reckless choices. However, when it comes to a criminal case, where the consequences could include months in jail, heavy fines, or even the suspension of your driving privileges, choosing to handle it alone can be a serious mistake. In situations where so much is at stake, representing yourself often falls into the category of something you can do, but absolutely shouldn't.
So you wish to represent yourself.
Yes, sir.
Do you read and write English for the record?
Yes, sir.
I'll provide you a document. It's entitled Waiver of Counsel. Take a few minutes to read it. If you find it acceptable, you can sign and date at the bottom. The court finds the defendant has executed in open court the written waiver of counsel document. In this case, Mr. Colton has decided to represent himself, so he will be pro se. Okay, Mr. Colton, I do not have a written bond recommendation from the prosecutor or law director, as this was a citation issued by the police officer, so I have to ask you a few questions. Do you live, the ticket has you at West Main?
Yes, sir.
What's the apartment number?
37.
37 in Pontiac. How long have you lived there? 4 years? Let's see, Mr. Colton has no prior criminal history in this court. And his last traffic violation was back in 2008. Mr. Colton does not represent to be a flight risk. I will set bond in the amount of $5,000 personal recognizance. And I will set this case for a pretrial conference in the near future. We're being released on your own recognizance, Mr. Colton. You're going to go, when you leave the courtroom, you're going to go to the clerk's window. They're going to give you a date and time for your next hearing. That will be the only notice you receive from the court, so make sure you put it on your calendar. If you fail to appear for that hearing, I'll revoke your bond and then I'll issue a bench warrant for your arrest, okay? You could also, the city of county, have $5,000 if you aren't here when you're supposed to be here. Do you understand?
Yes.
Do you have any questions for me?
Yes, I do.
And this is where things begin to get interesting. In most courtrooms, judges are limited in what they can say to the people appearing before them. They are allowed to answer questions about legal procedures, how the process works, or what step comes next, but they must remain completely neutral. Judges are strictly prohibited from giving legal advice to either side, because doing so could compromise the fairness of the case and make it seem like they are favoring one party over the other.
Okay, I am not your attorney. I am not your legal advisor. So if you're going to ask me, like you're not the first one who's going to ask me legal questions. I cannot answer your legal question, only procedure. So you have any procedural questions for me?
Yes, I do.
Go ahead.
I would like to know why I am not getting an accident report.
Mr. Colton, you're going to represent yourself. There are what we call rules of discovery. So I would advise you to talk to the prosecutor or law director's office, which is across the hall, and then they'll provide that to you.
Is there a reason you can't?
This is where we get into the situation where a non-lawyer isn't familiar with the procedures. The court doesn't provide discovery. Discovery is exchanged between the parties.
How come the records office will not give me a copy?
Talk to the law director's office. Okay?
Yes, sir.
Now, if things had simply ended there, the situation would have been straightforward. He had already been told where he could obtain his report, and the court had confirmed that he was allowed to represent himself. That should have been the end of it. But instead of leaving it at that, he chose to push things further, and what followed was a decision that turned out to be incredibly foolish.
Get back in here.
Sir, get back in court.
Sit down. What's your problem?
I believe I'm getting railroaded.
Yeah, the truth is you weren't being railroaded by anyone, you were doing it to yourself. Marching out the door with that little Thomas the Train routine only made things worse. In fact, it was probably the dumbest move you could have made in that moment. When you're standing in front of a strict, no-nonsense judge like this, the last thing you should do is act disrespectfully or turn the situation into a joke. All it did was make the situation look even worse for you.
You just pled not guilty to a charge. I found you not guilty. I've accepted the not guilty plea. Be quiet! Be quiet! Or I'll hold you in contempt of court. Now, why do you feel railroaded? Because you went to the police department and asked for a copy of the report. You went to the wrong office. And any attorney would know that. You go to the law director's office, which is prosecuting this case. And you don't get it from the court. Any attorney knows that. You might want to reconsider representing yourself, Mr. Colton.
No, sir.
Okay. Do you have any other noises you want to make before you leave this courtroom?
No, thank you.
Then get out of here without making a noise.
Yes, sir.
Alright everyone, that brings us to the end of the video. As soon as I came across this clip, I knew it was something you'd want to see for yourselves. If you enjoyed the video and found it interesting, make sure to show your support by leaving a like and sharing your thoughts in the comments below. Your support really helps the channel grow and lets me know you want to see more content like this.